Welcome to BLM's next instalment of the What If podcast series. I'm Chris Dexter, one of the partners within the National Healthcare team here at BLM, and today I'm joined by my friend and GP, Dr. Ruth Camish. Dr. Camish is a GP partner at a surgery in Manchester and has a specialist interest in gut health and its effect on the skin. She's an avid Instagrammer on the topic, so I thought she'd be best placed to come and help me with this podcast and to be our usual GP. We're going to be discussing what happens at the trial, and I'll be answering some questions from Ruth, which the regular healthcare professional working in the field may find of benefit. Now, my understanding, Ruth, is that you've never been involved in a trial, is that right?
Yes, that's correct.
So how can we help you demystify this?
Yeah, thanks, Chris. I think you're right. It is a mysterious process for healthcare professionals, and I think it's my ultimate fear that it might happen. So what would the circumstances be that a complaint or a case would end up at trial?
So there'd be a clinical claim to start off with. You'd know about it before it got to the trial for quite a long time. It can take sort of about 2 years-ish before it got to a trial. It's very rare that it gets to a trial.
Okay.
The concept of the trial is to only adjudicate on the parts of the case that are in issue. So the life of the claim will result in parts of it reducing and being agreed or not being proceeded with, so that when you got to the trial, there'd only be certain bits that you want the judge to look at the end.
Okay. So my experience of a legal process has all been from what I've seen on TV. So who would be in the room?
So most people's experiences from watching television, mainly American television programs, but unfortunately the English and Welsh legal system is not as exciting.
Okay.
You will have seen all the documentation involved with the case before you get to a trial. You'll have seen all the witness statements, all of the expert evidence, and you will have had an opportunity to respond to the allegations already by way of a defence. If you get to a trial, and again reiterate, it's a rare process, the judge would be there, there'd be no jury. The claimant would be present. They might be there with some family. Their experts would be there. You'd be present. You'd have to take some time off work to come and give evidence.
Okay.
And your experts would also be present together with your barrister and your solicitor.
Okay. So what advice do you give a client about the kind of language that they use when they're presenting their statement?
So if you're giving evidence at a trial, you'll be in the witness box. You'll answer questions from the claimant's barrister in cross-examination. You're only answering the question that they're putting to you. You're not being asked to give a reason as to why the case has got this far. You're not being asked to give a diagnosis for the patient. You're not being asked to say whether the patient's claim is right or not. You're just answering the question that's being put to you.
Okay, so yeah, that's helpful. What advice do you give people about if there has been a mistake and they might want to apologise?
So if there's been something that's gone wrong in the treatment, for example, and you feel it's necessary to make an apology, you can be given the opportunity to do that whilst you're giving your evidence. Sometimes that opportunity can have been occurred earlier in the case and that apology can have been given in a written format.
Okay.
But sometimes it feels right to give an oral apology, especially if the family are present as well. It might be able to help give some closure and give a formal response from you as the practitioner to the family that are there.
Yeah, okay. So it sounds like there's quite a lot of advice that you get as you go along and that it's a very supported process from the team.
From my perspective, that's how I like to deal with it. Make sure that the practitioner knows what's happening, what could happen, and that it's a team effort.
Yeah, I think that's really reassuring. So what happens next?
So the judge, once they've heard all the evidence, will either make a decision on the case at the end of hearing all the evidence, who's won or who hasn't. Sometimes, because these cases are quite complex, it can take longer for him to come to his decision, and he provides a written decision later on that's sent through by email, usually to the legal teams involved. So it can be an even more longer drawn out process than just the trial itself. But hopefully that gives you some way of demystifying this. It's a rare process, only about 1% of cases get to trial, and hopefully that's been useful for you.
Yeah, that's been really helpful. I think a lot of healthcare professionals will feel pretty reassured by the explanation that you've given. Thank you.
Good, thank you. And thank you for joining us today and to listening to our discussion, and we hope that you found this podcast useful.